Hi there, how are you doing? In this video, we are basically going to be looking at the principle of rational Dystendai, or you can also call it a doctrine. And we are basically going to define it, and we'll also give examples by way of case law to illustrate this principle of rational Dystendai. But we'll also share with you the position of the law on the doctrine of rational Dystendai. So basically, this doctrine of ratio decidendi, or the principle of ratio decidendi, means the reasons or grounds upon which a judicial decision is based. That's what it means. It is the ratio decidendi of the case which makes a judicial decision or judgment. Okay? This principle is to be found by taking accounts of the facts treated by the judge as material and his decision as based on them. What is also important to note on this doctrine of ratio decidendi is that it is actually binding. It is the ratio decidendi of the case that is binding, and it is the ratio decidendi of the case that is of a binding nature to subordinate courts. Now, when you look at a whole judgment, a judgment can be very long. It could be 100 pages, 50 pages, or anything around there. But not the whole judgment is the ratio decidendi. The judgment actually in itself has so many contents, including facts. It has the facts of the case. It has the submissions of both advocates. A judgment includes the obiter dictum. It includes so many elements. And it also includes the analysis and the conclusion of the judge. But however, in the contents of a judgment, there is an aspect known as the ratio decidendi, which we earlier said that this is basically the reasons or grounds upon which a judicial decision is based. Now, that ratio decidendi is actually what forms the gist of the judgment. Those are the reasons on which a judgment is based, the reasons and grounds upon which a judicial decision is made. Again, it's important to note that it is the ratio decidendi that actually forms the binding element of the case. It is the decision, okay, of that case. There is a law, ladies and gentlemen. The ratio decidendi is also provided for by the law, and it is a requirement of the law that when judgment is given, it must actually contain a ratio decidendi. It must contain the reasons and the grounds upon which a judicial decision is based. The judge must have the ratio decidendi in his or her judgment. Authority for that position, I encourage you to go and look at section 136 of the Magistrate Courts Act, Cap 16, and also you look at also section 68 of the Trial and Indictments Act, Cap 23. These sections, both of them, provide for the requirement of a judgment having reasons upon which a judgment is based. So the position of the law is that when a judgment is being made, it must have the reasons on which the judge has based to make a conclusion. And that actually forms the ratio decidendi of the case. Having laid down the law and defined what ratio decidendi is, let's now proceed to share with you some of the cases that will illustrate a ratio decidendi. I'll share with you a very common case which you must have come across in law school by now, or if you haven't, you will soon come across it. It's a very common case for any law student, and that is the case of Khalil versus Carbolic Smoke Ball. Now, in that case, court held that the deposit of the £1,000 was an indication of a serious offer. So in that case, it was actually, that statement was the ratio decidendi, okay? That was the ground on which court concluded or held that indeed there was a valid contract. I'll also share with you another interesting Ugandan case, that is DPP versus Vesige. You can find it online. And basically in this case, Justice Katusi, before acquitting Vesige of rape, said that the evidence against Vesige was inadequate even to prove a debt, imported to define or to deprive of a civil right. ridiculous for convicting, the pettiest offense, and monstrous as if to ruin the honor of a man who had offered himself for presidency. So basically, when Justice Katusi was acquitting retired Dr. Kanokiza Besigye for the offense of rape, okay, on the basis that actually there was no sufficient evidence, or rather he actually relied on the fact that the evidence as provided by prosecution was so insufficient to convict retired Dr. Kanokiza Besigye, and that a conviction could not sustain on the evidence as was given by the state or by the prosecutor. So those two cases illustrate what we call a ratio Dystendai in the case. It's very, very important when you're reading a judgment to always read the whole of it. It is only when you read the whole judgment that you're able to extract the ratio Dystendai. And as we said, it is always the ratio Dystendai of the case that is binding on other subordinate courts. Ladies and gentlemen, that was all for today's class. Again, I encourage you to ensure that you subscribe to my channel. Also turn on your notification and share and like this video with your colleagues so that they are able to benefit. Once again, for students who require private law tutorial sessions, our numbers are down in the description box. Please contact us for a private arrangement or for a one-on-one engagement. Thank you very much. We meet again in another class. Bye-bye.